There is a video title that has been circulating on YouTube for years. Get a U.S. green card in 6 months. You have probably seen it. Maybe you have clicked on it. And if you watched long enough, you probably found out that it is either misleading, outdated, or describing a situation that applies to almost nobody watching. Here is the honest truth that most immigration videos do not tell you. The U.S. green card process in 2026 has a backlog of over 11 million pending cases, the largest in USCIS history. For most pathways, family preference, employment-based for applicants from India and China, diversity visa, the realistic timeline is measured in years, sometimes decades. A green card in 6 months is not a realistic expectation for the overwhelming majority of applicants in 2026. But, and this is the part those clickbait videos get right by accident, the fastest pathways genuinely are fast by immigration standards. And some of them are faster than most people realize, for specific types of applicants in specific situations. The fastest employment-based green card currently processes in 12 to 18 months, with premium processing for applicants from most countries. A marriage-based green card for the spouse of a U.S. citizen can be completed in 10 to 17 months for the best-prepared applicants filing from inside the United States. And a very specific investor pathway has moved from 3 to 4 years to 12 to 24 months for those with the capital. This video is the complete, honest, verified breakdown of every legitimate U.S. green card pathway ranked by speed in 2026. What makes each one fast, who actually qualifies, the exact realistic timelines from start to card in hand, and the specific things that make applications faster versus slower. No false promises. Number 6-month guarantees. Just the real picture. So you can identify which pathway is genuinely fastest for your specific situation and pursue it with accurate expectations. Let us start. Welcome to the channel. This video covers every major U.S. green card pathway ranked by realistic total timeline, from fastest to slowest, based on current USCIS processing data as of August 2026. I will explain what a green card is, why timelines vary so dramatically, the 2 clock problem that most videos never explain, and then walk through every major pathway with verified timelines and honest eligibility requirements. Everything in this video is sourced from official USCIS data and verified U.S. immigration law resources. Let us begin with the foundation. A U.S. green card, officially known as a lawful permanent resident card, is one of the most valuable legal documents available to a non-U.S. citizen in the world. It grants you the right to live permanently in the United States without any expiration of that right. It grants you the right to work for any employer, change jobs freely, start a business, or work for yourself, without needing any employer to sponsor a visa. It grants access to public education for your children, access to certain public benefits, the ability to sponsor certain family members for their own immigration, and the ability to travel internationally and return to the United States without restriction. After holding a green card for 5 years, or 3 years if married to a U.S. citizen, you become eligible to apply for U.S. citizenship, which provides the right to vote, the right to a U.S. passport, one of the most powerful travel documents in the world, and the right to full political participation in American life. Green card processing time in 2026 typically ranges from 10 months to over 15 years, depending on your category, country of birth, and visa availability. That extraordinary range, from 10 months to 15 years in the same system, is the central challenge of U.S. immigration. And understanding why it varies this much is what allows you to choose the fastest, realistic pathway for your situation. Before we rank the pathways by speed, I need to explain something that most immigration videos either skip entirely or explain so poorly that it creates more confusion than clarity. It is called the 2 clock problem, and understanding it is the key to understanding why U.S. green card timelines are so much more complex than they appear. Clock 1, USCIS processing time. This is the time USCIS takes to review and make a decision on your petition or application. It is the time you typically see quoted on immigration websites and YouTube videos. For example, USCIS currently processes employment-based I-140 petitions in approximately 8 to 28 months, depending on the category and the service center. This is Clock 1. Clock 2, Visa Bulletin Wait, Priority Date Wait. This is the clock most people do not know about, and it is often longer than Clock 1. The United States limits the number of employment-based and family preference green cards issued per year across all categories. There are annual caps, approximately 140,000 employment-based green cards per year total, split across 5 preference categories. And within each category, no single country can receive more than 7% of the annual total. This per-country cap is what creates dramatic differences between applicants born in different countries applying under the same category. When demand for a specific category from a specific country exceeds the available quota, USCIS creates a waiting line measured by your priority date, the date your petition was filed. You can only move forward to the final green card application stage once your priority date is earlier than the dates published in the monthly visa bulletin. For some categories and countries of birth, particularly India and China in the EB2 and EB3 categories, this wait is not months. It is decades. Why this matters practically. Employment-based cases run from as little as 15 business days with premium processing to more than 36 months without it. That quoted range is Clock 1 only. For an applicant born in India under EB2, Clock 2 adds a minimum of 12 additional years as of April 2026. The total realistic timeline is not 15 business days. It is 12 years plus processing time. The fastest green card pathways are the ones where Clock 2 is either 0, meaning the category is current and has no backlog, or is very short. Every pathway I rank in this video will include both clocks, so you understand the complete picture. Pathway 1. Marriage to a U.S. citizen. Immediate relative category. Timeline. 10 to 17 months in USA, 14 to 24 months. From abroad, Clock 2. 0. No annual cap, no backlog. Immediate relatives of U.S. citizens often receive their green card within 10 to 20 months. The fastest and most consistently accessible green card pathway for most people who qualify is the immediate relative category, specifically being the spouse, unmarried child under 21, or parent of a U.S. citizen. Immediate relatives are not subject to any annual numerical limit. There is no cap on how many green cards the U.S. issues to immediate relatives of citizens in any given year. This means there is no priority date wait. Clock 2 is 0. The only wait is USCIS processing time, Clock 1. For a spouse of a U.S. citizen living in the USA, the process from filing to holding the card in hand is roughly 14 to 22 months in 2026. For the very best prepared applicants filing from inside the U.S. with complete, well-documented applications and no complications, timelines at the shorter end of this range are achievable. The process from inside the United States, adjustment of status. If you are already legally present in the United States, you file I-130, the petition for alien relative, and I-485, the application to register permanent residence, simultaneously. You can also simultaneously file I-765 for a work permit and I-131 for travel permission. This concurrent filing means that while your green card is being processed, you can legally work and travel. The work permit is often approved within 3 to 5 months, significantly before the green card itself. The process from outside the United States, consular processing. If you are outside the United States, your U.S. citizen spouse files the I-130 petition first. Once approved, the case transfers to the National Visa Center, NVC, for document processing, then to a U.S. consulate in your country for an immigrant visa interview. After USCIS petition approval, NVC processing takes 3 to 5 months. Then interview scheduling takes 1 to 3 months, adding 4 to 10 additional months to the overall timeline. What makes this pathway faster? Submitting a complete, well-documented application the first time. Complete means every form fully filled, every required document included and clearly labeled, every supporting evidence organized and compelling. Applications with missing documents or unclear evidence receive requests for evidence, RFEs, which add months to the timeline. Genuine marriage documentation, photographs across years, joint financial accounts, shared lease or mortgage, evidence of cohabitation, communication records, Submitted proactively rather than only in response to an RFE. The honest reality. The marriage-based green card is the most common pathway, but also receives the most scrutiny. USCIS heavily scrutinizes these cases for genuine marriage intent. A fraudulent marriage for immigration purposes is not just a pathway to denial. It is a federal crime with serious consequences. Every applicant using this pathway must be genuinely married with a genuine, ongoing marital relationship. USCIS and consular officers are specifically trained to identify marriage fraud, and the interview process is designed to assess genuineness. Pathway 2, EB-1A, Extraordinary Ability, the Einstein Visa. Timeline: 12 to 18 months for most countries, longer for India/China. Clock 2. 0 for most nationalities, currently no backlog. The fastest way to get a U.S. green card in 2026 for employment-based applicants is the EB-1A Extraordinary Ability, which is current for most countries and reaches approval in 12 to 24 months total when premium processing is used for the I-140. The EB-1A is the most powerful self-directed employment-based green card pathway in the entire U.S. immigration system, and it has two features that make it extraordinary. First, no employer sponsorship required. You file your own petition. You do not need a company to sponsor you, hire you first, or go through the perm labor certification process, which adds 12 to 24 months to most other employment-based pathways. Second, for most nationalities outside India and China, the EB-1A category is currently current, meaning Clock 2 is 0 and there is no priority date wait. Processing typically takes 6 to 19 months as of 2026. With premium processing available for 15 business day adjudication. Premium processing costs $2,965 as of March 1, 2026, and guarantees a USCIS decision on your I-140 petition within 15 business days. It does not guarantee approval, only a decision. But combined with a strong petition, it dramatically accelerates the timeline. Who qualifies? The honest picture. The EB-1A is for individuals who have risen to the very top of their field in science, arts, education, business, or athletics. You must demonstrate either a one-time major international award, Nobel Prize, Olympic medal, Academy Award, Pulitzer, or meet at least 3 of the following 10 USCIS criteria. Criterion 1, prizes or awards. Receipt of lesser nationally or internationally recognized prizes in the field for excellence. Criterion 2, membership. Membership in associations that require outstanding achievement as a condition of membership. Criterion 3, published material. Published material about you in professional or major trade publications or major media. Criterion 4, judging. Participation as a judge of the work of others in the same or allied field. Criterion 5, original contributions. Evidence of original scientific, scholarly, artistic, athletic, or business-related contributions of major significance. Criterion 6, scholarly articles. Authorship of scholarly articles in professional or major trade publications or major media. Criterion 7, artistic exhibitions. Evidence of the display of your work at artistic exhibitions or showcases. Criterion 8, leading or critical roles. Performance of a leading or critical role at distinguished organizations. Criterion 9, high salary. Command of a high salary or remuneration in relation to others in the field. Criterion 10, commercial success. Evidence of commercial success in the performing arts. Meeting 3 criteria is the threshold, but it is not sufficient on its own. USCIS uses a 2-step framework from the 2010 Kazarian v. USCIS decision. After meeting 3 criteria, USCIS conducts a final merits determination, assessing whether the totality of evidence demonstrates sustained national or international acclaim and positions the applicant among the small percentage at the very top of their field. Many petitions fail at this second stage not because evidence is absent, but because the attorney fails to explain why the evidence proves extraordinary ability. The common misconception: you do not need a Nobel Prize. Most people qualify by meeting at least 3 of the 10 criteria. You do not need a Nobel Prize or an equivalent award. What you need is significant recognition in your field and awards that are specific to your field of expertise and show sustained impact. Professionals who have successfully obtained EB-1A green cards include technology entrepreneurs who have built products with millions of users, medical researchers with significant publication records and citation counts, engineers who hold patents with documented industry impact, artists with international exhibition records, business executives in named leadership roles at recognized organizations, athletes who have competed at national or international level, and academics with strong peer review and conference speaking records in their field. Petitioners who succeed in 2026 typically planned their evidence portfolio 1 to 3 years before filing. The steps include publish in peer-reviewed journals or conference proceedings, file patents, speak at flagship industry conferences as an invited speaker, serve as a peer reviewer or grant panel member, take named lead or principal roles on projects with external visibility. The country-specific consideration. For China and India, the April 2026 Visa Bulletin confirms retrogression is back. Final action dates hovering around April 2023 for both countries. Even with an approved EB-1A, applicants from India and China may face a 2 to 3 year wait to actually receive their green card. All other countries remain current, allowing concurrent filing of the I-140 and I-485. For applicants born outside India and China, the EB-1A with premium processing remains the fastest employment-based pathway available. Pathway 3, EB-1C, multinational executive or manager. Timeline, 12 to 24 months. Clock 2, 0 for most nationalities. The EB-1C is the pathway for senior executives and managers transferring to the United States from a multinational company's foreign office. Unlike EB-1A, which requires extraordinary ability, EB-1C requires managerial or executive experience at an affiliated multinational, making it accessible to a broader range of senior corporate professionals. To qualify for EB-1C, you must have been working for the multinational company outside the U.S. for at least 1 year in the 3 years preceding the application, and you are being transferred to a U.S. branch, affiliate, or subsidiary of the same company. The U.S. employer petitions on your behalf. You cannot self-petition, as you can with EB-1A. The key advantages: no perm labor certification required, no extraordinary ability standard, and for most nationalities, no priority date backlog. The key limitation: you must have the right corporate background at a qualifying multinational. This pathway is not available to self-employed professionals or those without a qualifying corporate transfer relationship. Pathway 4, EB-5 investor, rural set-aside. Timeline, 12 to 24 months. Clock 2, 0, no backlog for any nationality, including India and China. EB-5 rural set-aside green cards process in approximately 12 to 24 months and are available to applicants from all countries, including India and China, bypassing the per-country backlog. The EB-5 is the U.S. investor green card. The minimum investment required is $800,000 for rural or high unemployment targeted employment areas, TEAs, and $1,050,000 for all other areas. The rural set-aside specifically refers to investments in projects in rural U.S. areas, which have a dedicated allocation of EB-5 visas that is separate from the general EB-5 pool and currently has no backlog for any nationality. The investment must create at least 10 full-time jobs for qualifying U.S. workers. Investments can be made directly into your own business or through USCIS designated regional centers, pre-approved investment pools that handle job creation requirements on the investor's behalf. The EB-5 is the only pathway that allows applicants from India and China to bypass their country-specific backlog and receive a green card in approximately 12 to 24 months, the same timeline available to all other nationalities. This makes it strategically valuable for high net worth professionals from high backlog countries. The honest caveat: $800,000 minimum investment is the entry point. This pathway is accessible only to applicants with significant capital to deploy. It is also important to work with qualified legal and financial advisors. The EB-5 space has historically attracted fraudulent regional centers and investment schemes. Always verify that your regional center is currently USCIS designated and has a verifiable track record. Pathway 5. EB-2 NIW. National Interest Waiver. Timeline. 2 to 4 years for most nationalities, 13 to 15 years for India-born, 6 to 8 years for China-born Clock 2. Current for most nationalities, significant backlog for India and China. The EB-2 National Interest Waiver is the most popular self-petition pathway for professionals who do not meet the extraordinary ability standard of EB-1A, but whose work is genuinely important to the United States in terms of national interest, public health, scientific research, education, environmental protection, economic development, and similar areas. Unlike EB-1A, which requires being at the very top of your field, EB-2 NIW requires demonstrating that your work has substantial merit and national importance, that you are well positioned to advance that work, and that it would benefit the U.S. to waive the normal requirement for a job offer. The standard is meaningful, but more achievable than EB-1A for a broader range of researchers, academics, healthcare professionals, engineers, and professionals in areas of national need. The challenge in 2026 is the country-specific backlog. EB-2 NIW for India faces a backlog exceeding 12 years as of April 2026. China's backlog is 6 to 8 years. For applicants born outside India and China, the EB-2 NIW category is currently relatively accessible, but for the world's two largest talent exporting nations, it is one of the most backlogged pathways in the entire system. Many attorneys file both EB-1A and EB-2 NIW simultaneously for clients who can credibly argue extraordinary ability but want to hedge against an EB-1A denial. The NIW is the safety net. EB-1A is the faster, higher approval rate path. Pathway 6, EB-3, skilled worker, professional, or other worker. Timeline, variable, 1 to 20 plus years depending on country of birth. Clock 2. Current for most countries. Severe backlog for India, Philippines, Mexico, China. The EB-3 pathway covers skilled workers in roles requiring at least 2 years of training or experience, professionals with bachelor's degrees, and other workers in unskilled roles. It requires employer sponsorship and perm labor certification, the process of advertising the role and demonstrating no qualified U.S. workers are available, which adds 12 to 24 months before the green card petition can even be filed. For applicants born outside the high backlog countries, EB-3 is a viable pathway, but slower than EB-1A due to the perm requirement. For applicants born in India, the EB-3 backlog is currently over 12 years, making it one of the longest waits in the entire immigration system. Pathway 7. Family preference categories. Timeline. 2 to 23 plus years, depending on category and country of birth. Clock 2. Significant backlogs across all family preference categories. Family-based I-130 petitions currently take roughly 20 to 129.5 months at USCIS, and the wait depends on your relationship to the sponsor. Family preference categories. For siblings of U.S. citizens, adult children of citizens, and relatives of permanent residents, are subject to annual numerical limits that create significant backlogs. The F4 category. Siblings of U.S. citizens from the Philippines, currently has a wait time of over 23 years. These categories provide pathways, but are not fast by any reasonable measure. Section 4. The factors that make any green card faster or slower. 29:00, 32:30. Practical and actionable. What viewers can actually control. Regardless of which pathway applies to your situation, there are specific, consistent factors that accelerate or delay green card processing. Let me give you the complete list so you can control what is within your control. What makes applications faster? File a complete application the first time. Attorney-filed employment-based cases achieve a 91% approval rate in fiscal year 2024, compared to significantly lower rates for self-represented applicants. The primary driver of that gap is complete, well-organized applications that avoid requests for evidence. An RFE can add 3 to 9 months to your timeline. Use premium processing where available. 4 employment-based I-140 petitions. Premium processing at $2,965 guarantees a 15 business day decision, converting months of standard processing into weeks. File concurrent applications where permitted. For immediate relatives and for applicants in current employment-based categories, filing I-485 simultaneously with I-140 means your adjustment of status application is already in queue while your petition is being decided. Respond to any RFEs immediately and completely. Every day you delay responding to a USCIS request is a day added to your processing time. Prepare your response as quickly and as thoroughly as possible, ideally within days, not weeks. Keep your contact information and address current with USCIS at all times. Missing an interview notice or an RFE because your address is outdated can result in your application being abandoned. What makes applications slower? Incomplete or inconsistent application packages. Missing forms, missing signatures, missing fees, or contradictions between different documents all generate RFEs or outright rejections that require restarting portions of the process. Previous immigration violations. Periods of unlawful presence in the United States can trigger bars, 3-year or 10-year bars from returning, that complicate consular processing cases. Spending 6 months to 1 year undocumented triggers a 3-year bar. More than 1 year triggers a 10-year bar. Always consult an immigration attorney before leaving the U.S. if you have any periods of unlawful presence in your history. Country of birth. This is the factor entirely outside your control that has the single largest impact on timeline for employment-based and family preference cases. Applicants born in India, China, Mexico, and the Philippines face dramatically longer waits in most preference categories due to per-country caps. The 2026 green card backlog at a historic high of 11.6 to 12 million pending cases means that desperate applicants are an attractive target for immigration fraud. Let me be very direct about something important. The U.S. immigration industry has a serious fraud problem. There are individuals and organizations, some presenting themselves as immigration consultants, notarios, or agencies, who take large upfront fees from desperate applicants and either disappear, provide worthless services, or commit fraud on the applicant's behalf that results in severe immigration consequences. The specific scams to be aware of in 2026 include agents claiming they can guarantee green card approval for an upfront fee. Notarios, individuals who are not licensed attorneys, providing legal immigration advice they are not qualified to give. Fraudulent EB, 5 regional centers collecting investor funds for non-existent or non-qualifying projects. And individuals claiming to have connections at USCIS who can accelerate processing for payment. USCIS does not work this way, and anyone claiming otherwise is lying. Legitimate immigration attorneys are licensed by state bar associations in the United States. Always verify your attorney's bar membership through your state bar's public database before engaging their services. Never pay anyone who claims to guarantee an outcome. And always pay USCIS fees directly to USCIS through the official pay.gov portal. Never to an intermediary. Let me give you a direct decision framework based on your specific situation. If you are married to a U.S. citizen, the immediate relative pathway is your fastest option. File from inside the U.S. if you are already legally present. File from your home country through consular processing if you are outside. Timeline: 10 to 24 months. If you are a senior professional with documented extraordinary achievement in your field and you were not born in India or China, EB 1A with premium processing is your fastest employment-based option. Timeline: 12 to 18 months. Begin building your evidence portfolio today. If you are a senior executive or manager at a multinational company with U.S. operations, EB 1C may apply. Speak with your company's HR and immigration counsel about whether a qualifying transfer arrangement exists. If you have $800,000 or more to invest, EB-5 Rural Set-Aside bypasses all per-country backlogs and is accessible regardless of nationality. Timeline: 12 to 24 months. Always work with verified legal and financial counsel. If you are a researcher, academic, or professional whose work serves U.S. national interest, EB-2NIW is your pathway if you were not born in India or China. If you were born in India or China, file EB-1A if you can meet the extraordinary ability standard, as it currently has a shorter country-specific backlog than EB-2 for both countries. If none of the above apply, the standard employment-based routes, EB-2 and EB-3 with employer sponsorship or family preference categories are your options. These are slower. Set realistic expectations based on your country of birth and your specific category. And that is the complete, honest picture. The legitimate U.S. green card pathways ranked by speed in 2026. The fastest for most people in the right situation is the immediate relative pathway at 10 to 24 months for spouses, parents, and children of U.S. citizens. The fastest employment-based pathway is EB-1A at 12 to 18 months with premium processing for most nationalities for individuals who can genuinely demonstrate extraordinary ability. The EB-5 rural investor pathway at 12 to 24 months bypasses all per-country backlogs for those with qualifying capital. And the EB-1C pathway at 12 to 24 months serves senior multinational executives. None of these are 6 months. I will not pretend they are. But for the right applicant in the right situation, these are genuinely the fastest legitimate pathways to one of the most valuable legal documents in the world. Knowing which pathway applies to you is step 1. Preparing the most complete, most compelling, most well-documented application possible is step 2. And working with a qualified, verified, licensed U.S. immigration attorney for any of these pathways is the most reliable way to achieve the fastest possible result without errors, delays, or fraud. If this video gave you a genuinely clearer and more honest picture of what is possible, give it a thumbs up and share it with anyone you know who is navigating the U.S. green card process. Subscribe for more honest immigration guides from around the world. And drop a comment telling me your situation and which pathway you are exploring. I read every single one. For professional support with your specific immigration pathway, whether it is preparing an EB-1A evidence portfolio, a marriage-based application, or any other route, always work with a licensed U.S. immigration attorney. See you in the next video.